SJC-13797, Courtney Giraldi et al. Versus Roberta Orsi et al.
Okay, Attorney McCullough, whenever you're ready.
Good morning. May it please the court. My name is Scott McCullough. With me is co-counsel Paul Revere. Plaintiffs who could make it because of their condition of the weather are also in attendance. My sister and industry amici make this out as a wireless case with a health angle. We submit they are wrong. This is a public health matter where a local board was trying to enforce state law mandate when it found a situation that was injurious to public health, inhabitants, and estates. Chapter 111, Sections 122, 143, and other provisions in state law. It happened to involve a wireless company. The question here is whether a state law board trying to comply with the state law duty to investigate and eliminate public health threats that it finds are occurring is precluded from doing so because of federal law.
I don't know if that's exactly the question, at least in my view. In my view, the question is whether the board could rescind its show cause order, correct? Because that's the only thing that's on appeal here.
Procedurally, what happened was they entered the show cause order.
Yes.
And then after they were denied the ability to defend that order in federal court, they rescinded it.
Right. So the question here, and that's the order that's on appeal, is the rescission order.
It is. That is the one we challenge under Judicial.
Correct me if I'm wrong, but don't we review that to determine whether the board acted arbitrarily or capriciously in rescinding its previous order?
I believe the standard of review is whether it was in compliance with law, arbitrary, capricious. And here, remember, we do have a state law mandate to eliminate public health threats. It had found there was a public health threat.
Well, it might be arbitrary and capricious if the rescission order violated the law. I mean, that might be, but I thought the standard of review is arbitrariness or capriciousness.
But there is also the legal angle. They had a duty to eliminate this threat that they found. And even when they were rescinding the order, they reaffirmed the belief that it was a public health threat.
It seems to me that the question is whether the board acted arbitrarily and capriciously when it determined, based on preemption grounds, that it needed to rescind its order. Because it doesn't look like they rescinded their order because they disagreed with the public health aspect. It looks as though they rescinded their order purely based on their understanding of preemption.
I would disagree with that, Your Honor.
You think they rethought the health?
No.
No.
No, what I think happened was they truly believed in what they were finding in the show cause order. And they only rescinded it because they were denied a defense. They could not have counsel before the federal court. And in the face of this situation, they decided to rescind the order. Every single one of the board members, when they took the rescission vote, reaffirmed their belief.
So that's even a harder case for you, because what you're challenging is the a decision on what resources to allocate to what. You know, like we're just not going to have, we're not going to pay for counsel. And so the decision of the board is really yeah, we're not going to do this on our own dime, and we don't have dollars from the city to help us.
They get their budget from the city, and there was not money in their fund to do this on their own, but they could not do this.
So your argument is that it's arbitrary and capricious to make this resource allocation decision.
I would contend that it is contrary to law to fail to act to remove a public health threat that you have found to exist.
When you don't have the funds to do it.
Well, enforcement of the order is one thing, and they were not trying at the time to enforce the order. The show cause order was, Verizon, please come and talk to us. We want to try to work together to eliminate this threat. There are things that could be done to reduce the health threat.
Yeah, I don't know if that argument really helps you either, because then it's not even a conclusion that the order is preempted by federal law. It's, we are using this as a bargaining power in order to bring Verizon to the table. And we're determining based on a lack of resources that that's just no longer worth our time.
They are
Properly
precluded
phrased.
by the municipal charter from hiring their own counsel. That, I guess, implicitly includes spending money for their own counsel.
I would think so.
So they were denied the ability to do what they want to do. They wanted to do this, but because they could not have counsel, they had no choice but to issue the rescission.
So
The issue here is whether state law
well,
commanded them to continue to try to enforce state law however they could.
it sounds like the issue is whether the board acted arbitrarily and capriciously in
would contend-
rescinding its order because it had to stay within the confines of the town charter.
Well, again, we are not faulting the board's actions.
Well, you are
But what we
faulting.
are saying is that the board was coerced into doing what it had to do. And I guess you could say that is arbitrary and capricious. If you look over in the federal administrative law context, there's a whole line of cases about outside political interference with adjudicatory action. And it does look at it sometimes through the lens of arbitrary and capricious. But really, it is whether the action itself was based on the record and compliant with law.
Almost none of this is brief. Can we talk a little bit about what you argued, which is that it's not preempted?
Yes.
Okay, so I read some of these cases. What's the best case for you that says it's not preempted? Because they're going to stand up and cite about 30 cases where something very similar to this is preempted. So the only case you cite in your brief is a case involving the federal agency. It's not even a state agency case. So what's the best authority for you in a similar context that says this is not preempted?
I would start with this court's decision in Little.
Blue is not one of these cases, right? You're talking about a general.
It is not a wireless case. Well,
This is, wireless is an area that the feds have a lot of say in. So again, this is a kind of issue that comes up around the country. Give me one case that I can look at that comes out your way.
the first thing that I would suggest is you have to understand the lens through which to look at it, especially
I understand the lens.
when we are dealing with conflict.
I just would like a case, because it would really be helpful if I have a case that does what you want us to do.
On wireless,
Yeah.
are you speaking to express preemption or
Any
conflict?
kind of case that allows a local agency to do what you want to do here. Because I have a bunch of sites going the other way, but nothing your way.
I would cite to the Federal Communications Commission itself,
That's a
which
case involving the Federal Communication Commission's actions itself. It's not a case in which a local agency was allowed to do what you say should be done here.
This is a case of first impression in the country.
It can't be a case in around the country.
I'm not aware of any other health board that was called upon to investigate this.
So when she stands up, she's not going to have any cases like this where preemption was found? She's going to come up, I think, and say,
Yes, many of them will be either in a tort case context under conflict preemption, or they will be zoning cases where certainly the statute does apply, 332C7B IV. But our contention under express preemption is that that whole piece of it does not apply because it is limited to zoning. Now, I do want to return to the FCC if I could, because it's really important to understand. The commission has ruled that generally applicable health and safety laws are not preempted.
I thought they say the opposite, that the locals have an ability to site these telecommunication towers. Locals have an ability to say, this part of the town is not subject to that. What they can't do is use the health consequences of a radio tower to limit what the radio tower can do once it's been sited. That's why I'm asking you for a case in which someone says you can do that.
If you are speaking in the context of express preemption, then we have to work through the statute, first of all, to figure out whether it applies at all. And remember, this is a clause to a subparagraph to a paragraph that has in the caption of it, preservation of local zoning authority. So that is a zoning statute. The whole paragraph itself simply does not work when you have a situation like a health board. The second thing here is, as we have suggested below, my sister and the industry have yet to explain or accept that these networks themselves, they are a patchwork. And there are any number of ways to adjust this, many of which might not involve changing the level of energy that is being projected by this. They could just change the angle of the antenna, for example, so that it goes higher above the roofs in Shacktown to reach out to the Berkshires where this was designed to serve. These cell towers are indeed patchworks.
Counsel, I'm getting confused because it seems like you're jumping all over the place from where we were in the briefing. You keep talking about express preemption. How does this fit into Judge Flannery's decision? Because Judge Flannery's decision wasn't grounded in express preemption.
That is correct.
It was in conflict preemption.
That is correct.
So you're all over the place in what these issues are. So explain to me how Judge Flannery got this wrong under conflict preemption, where if you can't get in the way of where you have some say in where the towers can go. But if you're going to then do something that's going to affect the operation of it, that you can't do this. And Judge Flannery was pretty deliberate in walking this through and saying, okay, operationally, this was what this would do. And they found that they can't do this under preemption. And that's why they pulled back on the board pulled back on what they did. And why was that wrong?
First of all, I need to take issue with the proposition that the board found that they couldn't do it because of preemption. They never made that finding.
Well, they rescinded, whatever it is that you characterize it, you can characterize it any way you want, but they rescinded it.
They did. Okay? Conflict preemption is this particular variant of conflict preemption because impossibility preemption was never raised. This is called purposes and objectives preemption. And so the question before the Superior Court was whether the board show cause order, if it had remained in effect, would substantially interfere with the purposes and objectives of the FCC rules.
Sure, it would have, because it would have shut it down. It would have shut it down.
Not necessarily.
Well, okay, if I'm going procedurally with what happened here, I know you're playing games with the labeling here, but they issued the order to show cause. Verizon didn't come to the table, and it in effect became a cease and desist order. You can't argue with that. Okay?
I do take some issue with the general proposition that
The letter itself,
shut down.
the
They did not.
letter itself said that.
What the letter said was, we find that you are violating the health code, and we want you to come in to find a way to no longer do that.
Why don't you quote the letter itself? What happens after the 7 days when Verizon doesn't come to the table? What happens?
The ordering provisions on page 14 in the record, A at 79, said in paragraph 8 that Verizon should come in and request a hearing. And if it did not, then it should abate and eliminate all activities and operations leading to the present and ongoing nuisance and violation.
So it shuts it down.
Not necessarily. Verizon could have solved this by doing something to the tower that would have quit making people sick. And that did not necessarily involve shutting it down.
If Verizon did none of those things, they couldn't operate, right?
Verizon could have, for example, and this is laid out in the argument.
You're not answering any of our questions.
I apologize.
If Verizon didn't do any of that, the board said stop operating that tower.
Instead, stop violating the health laws.
Okay, well,
Eliminate all
you want
operations leading to the present and ongoing nuisance and violations. That doesn't absolutely and clearly say turn off the tower.
Well, if actually what they wanted was for them to reduce the amount of emissions coming out of the tower, and that's where it gets to the heart of the conflict preemption problem here that was identified, right? Because you would concede that there is a purpose of the statute is to preempt a patchwork of emission standards across the country, would you not?
The board did dedicate a lot of discussion in the first part of the order to talking about RF emissions. They did. But ultimately what their goal was to stop the illness. And if Verizon had merely come and gotten past its argument that you are preempted, and two, this can't be hurting people, which the board found was not credible, then we would have had many opportunities to try to figure out a way to stop making people sick while still allowing Verizon to meet its service objectives. And I will tell you, there are many ways that this could be done. It was simply that we never got to that point. Now, patchwork. I cannot emphasize to you enough that these cellular networks are patchwork networks. Every single cell site is different. Some tall, some short.
Can I get you to focus on the law for a second?
Yes.
So 332C7B4. Doesn't that preclude what you're saying? You can't do anything to the extent that such facilities comply with the FCC's regulations concerning such emissions. Don't you run smack into that?
I have two answers to that.
Go ahead.
First of all, again, I contend C7 and C7B does not apply to this context. It's about zoning. But second, the answer is actually not. The FCC guidelines set out a maximum permitted exposure level beyond which they are not supposed to go. But also, there is a federal statutory requirement to operate at the minimum power necessary. So the statute actually says you've got to, at all times, operate with the lowest power necessary, but you cannot exceed this amount. Now, what we think is entirely possible is that we can find a way so that they can still provide service, emit enough power necessary to effect the desired communications. But it might, perhaps, as one alternative, be to reduce the power level from what they have now. Now, the commission does say, the rules do say, you have permission to operate up to this amount when necessary to effect the desired communication. But the federal rule is also that you only do that when it is necessary to effect the desired communication. And The real rule.
What is the
to operate at
evidence in
minimum
the
power necessary.
record that Verizon is violating this range that you're talking about?
There was some evidence before the health board on their power emissions, and it did generally show that they were well within, admittedly, the maximum permitted exposure levels. But there was no evidence, Verizon certainly didn't put any in, showing what would be the minimum power necessary to affect communications.
And you didn't put any in?
We did not.
Okay.
In the footnote in your complaint, you say that as of the date of the complaint, there was no written order reflecting the rescission.
That's correct.
And the boards had not approved its minutes of the meeting at which they decided to rescind their order. If any of that is now available, I would appreciate it if you would file that with the court. I didn't see it in the record, and maybe I'm missing the rescission order in the record, but I couldn't find the rescission in the order or the board's minutes that would explain why it rescinded its order. Those seem to me to be important pieces of the record that should be supplied.
It's been a while since I've checked, to be candid, but last time I did check, it had yet to be memorialized in minutes. We do have the video in the administrative record that we supplied to the Superior Court of the vote.
Okay, well, it seems important to this case that we understand the reasons the board gave for its decision.
We'll be happy to supplement and get that before you.
Thank you.
Thank you very much. We ask that you reverse the Superior Court and send it back and let the court finish resolving the matter. Thank you.
Attorney Lord.
Good morning, and may it please the court. The board's position is that the Superior Court judgment was well-founded in the law and should be affirmed. This case presents a narrow issue. It's the extent to which the TCA preempts local and state governments and their instrumentalities like the Board of Health, the authority to make laws or otherwise regulate the telecommunications industry, including RF emissions that fall within FCC standards. If I may, I'd like to give a little brief case background because it's a convoluted history.
Before you do that, I just want to read the relevant language we're looking at is this regulatory provision that says expressly, no state or local government or instrumentality may regulate the placement, construction, and modification of personal wireless service facilities on the basis of the environmental effects of radio frequency emissions to the extent that such facilities comply with the Commission's regulations concerning such emissions, right? So it's,
Yes, Your Honor.
it's right there in black and white.
I agree with you, Your Honor. Although the Superior Court did found its decision on conflict preemption, we do believe that there is also express preemption. And as you know, on a de novo review, you can look at the record and rule any way you believe.
So
And
as to that language, though, why is environmental effects? Why does that include the health issues that are at the center of this?
Sorry, Your Honor. It's explicitly included in the statute that environmental effects includes potential biological impacts and health impacts.
What statute?
I'm sorry, I don't have the citation, but it is within the TCA. I will find that site. But yes, the TCA specifically includes health impacts as one environmental effect. And then going back to Justice Kafker's question, the reason, although that's in a zoning subsection, I would argue that it is in a zoning subsection that carves out a very limited safe harbor for local and state governments to have authority. And in carving out that narrow safe harbor, they further limited it to say that you still can't make even zoning decisions based upon these limits. So if you aren't permitted to make a zoning decision based upon those limits, once the tower is sited and constructed and operational, it would be counterintuitive to then say that local boards of health or other local instrumentalities or state government could then limit your operations when you're complying with
They do have, the local government has the ability to deal with modifications of, I don't know what that means exactly. Is that physical modifications? Is that defined in the regs of the state?
I did not see it defined. Modification can mean many things. It can mean physical modifications. It can mean modifications of RF emissions, right? So that is unclear. But in any event, those modifications aren't permitted if it's based upon RF emissions and perceived environmental impacts, which includes, again, health impacts. So, to say that you can build it, but then you can't turn it on after going through zoning, siting, licensing, construction costs, that seems to be a direct conflict with the goals and purposes of the TCA, which is to create a national uniform standard, because we have 351 municipalities in the Commonwealth alone. You can imagine a scenario, granted to the extreme, where every single municipality creates differing standards, at which point the services that are there are going to be interrupted. You're going to lose further investment in technological rollouts in those areas.
So back to Justice Kafker's question, and I'm sorry, Justice Kafker. It sounds like maybe that's where you were going. I thought your position initially was the Superior Court judge could have grounded this in express preemption. But now you're talking about what the Superior Court judge actually did do, which was the obstacle conflict preemption.
Correct, Your Honor. I do agree that the obstacle preemption is exceedingly clear in this case. And so I do think it's an easier ground. I do believe that zoning section shows the limitations of that safe harbor and therefore could form the basis for express preemption. But I do agree that Judge Flannery's decision as written was strong and that conflict preemption is the easiest path to take.
So there's serious health allegations here.
Yes, Your Honor.
And does the FTC have the ability to, because the FTC can come in and play with the they can play with the waves, right?
The FCC?
FTC.
Oh, I'm not sure, Your Honor.
What's the relevant federal agency?
FCC.
FCC. Can the FCC come in and deal with the health issues? They have the power to do what? I'm just trying to understand if this is a case where we're fighting the wrong battle on the wrong battlefield. Because it's troubling if people are getting sick that there's no remedy. But if there's an alternative federal remedy, it's a lot less troubling. So
yes, Your Honor. So there's a couple of options, right? So option one is, of course, you can work with your federal legislators and try to make a change.
Good luck on that.
Good luck. I agree. It's an option. I didn't say it was a pretty one. It does exist.
I'm just trying to understand, as a lawyer,
yes.
I'm dealing with health effects. Do I have a federal avenue trying to deal with the FCC to address these health problems?
You do, Your Honor. And in fact,
and how do you do that?
So under the rulemaking, so FCC actually engaged in further rulemaking in 2019, re-examining these 1996 standards. And in fact, a case, Environmental Health Trust, argued by my brother at the bench here, the DC Circuit didn't say that the levels were improper, but said we want more support from the FCC and remanded it back to the FCC for additional rulemaking. I am aware that the Environmental Health Trust case, there's been a fairly recent filing in that, seeking to have the DC Circuit push the FCC along on that front. You can also make FCC complaints. And I believe I have one more.
Can you make complaints based on the environmental effects of the wave? Again, I defer to my colleague, the MIT engineer, on what's happening with the radio wavelength. Go ahead.
You can. So we've got the DC Circuit. So again, you can file actions there. There is an action pending where this may, in fact, change some of those standards. We don't know at this point in time.
Is that a national case? But can you get to a local micro level with the FCC? Is there some regulations or statutes that allow you to do that?
On that, I don't know. I would presume that the DC Circuit Court would be the appropriate venue for anything involving that agency, but I am not certain of that at all. But I believe that because it's located in DC, it's a federal agency in DC, that the DC Circuit would be the appropriate court to take any such actions based on environmental impacts.
Am I correct that the record does not include the rescission decision of the board?
As you ask, I could not point directly to it. I've read obviously a lot of things. I do know that there's minutes from the executive, there was minutes from that meeting where they talked about why they did it.
All right, so that seems to me important to nail down because in the complaint, this was a motion to dismiss, so we're basically going to review that based on the allegations in the complaint. The factual allegations in the complaint concerning the rescission order are that the board was coerced in rescinding its order. It didn't say anything about preemption. It said that it was coerced because they were deprived of counsel, not given funds, et cetera, et cetera. And we would review that decision based on those allegations in the complaint ordinarily. Preemption seems to have been introduced somewhere along the line, and I'm not sure if it was actually a basis for the board's decision. In your brief, you actually mention it as being the basis in the conclusion, but in the body of your brief, you accept the contention that the board made the decision to rescind its order based on practical considerations. I'm really confused because I think that I'm not sure what the issue is, the legal issue in this case, given the state of the record. So can you help me resolve this in some way?
Yes, Your Honor. I would point out first that any and all aspects of the complaint that related to coercion or undue influence, those were all dismissed. They were not appealed. So those counts have gone away. They do not exist.
I'm talking about the factual allegations, not the count.
As it relates to the decision to rescind, that comes down, practical considerations. When I use that term, I was relating to the fact that it was based upon a review of the law relative to preemption. It was based upon the costs and the risks of litigation. In the face of that, that was the decision. So that's the practical.
So where do we see that in the record?
Yes, Your
that
Honor.
was the reasoning of the board.
As my brother mentioned, we will supplement with that piece. We do have those minutes, and we can make sure that they get to this court. And I believe you have the video, and we will make sure you have that as well.
So in the abstract, assuming the board made its rescission decision on a grounds other than preemption, why would we be considering preemption in this case?
But that was the practical consideration, Your Honor, because the costs of litigation, the likelihood of losing after spending taxpayers' money based upon the current state of the law, which says conflict preemption prevents the board from taking this action. Rescinding the order without prejudice was the most judicious use of our resources, and it was based upon the fact that preemption was going to defeat us.
So if the board were wrong on the issue of preemption, what's the standard? Does the board, in other words, I'm not sure that the standard of review is that if the board got that legal issue wrong, we would reverse the rescission order,
I agree.
right? Because I'm not sure that the standard is that they have to get the law 100% correct.
Right, Your Honor.
All right, so what is the standard?
So we believe the standard is arbitrary and capricious. And when you have a well-founded, reasoned belief, and then you make your decision accordingly, the decision to rescind that order, therefore, is not arbitrary and capricious. It's well-founded.
So can you address the argument raised, I think, in Verizon's brief that this whole action should be dismissed because a certiorari and a DJ is just not available in this context?
You know, it's an interesting argument. This case came before the Superior Court under Standing Order 1-96, which specifically allows for review of the decisions. The argument we would make is that, well, we're here, so we're reviewing it. But the second part I would say is that in terms of if you view it as a cert action, you know, the burden is on them to prove an error of law because they brought the action. And I don't think they've carried that burden. In terms of a declaratory judgment, you know, it's applying the law at hand to the basic facts at hand, and I think that, you know, there's clearly a controversy between the parties, not necessarily in the law, and that they want clarification. So I think in either case, we prevail. Judge Flannery's decision was well-founded. The board's decision in rescinding the order was reasoned and based on law. As I was going back to my other argument, I'm sorry. We note that in terms of telecommunications and radio, the one thing I do want to point out is we refer to the Telecommunications Act of 1996 a lot, but the originating authority for the FCC is actually much older. It's the Communications Act of 1934. And under the 1934 Act, they were given broad authority to craft these regulations. In fact, they had started rulemaking relative to RF emissions before the Telecommunications Act of 1996. And in the Telecommunications Act of 1996 is where Congress specifically instructed them to create these standards under their rulemaking authority. So again, this was something where Congress has explicitly stated that they want the FCC to regulate this particular area. And again, you know, we go back to the proposition that to hold preemption does not apply in this case and does not apply to cases where people are complaining of health impacts due to RF emissions opens the floodgates. And, you know, as I said, 351 municipalities in Massachusetts alone, you extrapolate that to New England, you extrapolate that to the United States, and it very quickly becomes untenable amount of standards that companies and communities would have to.
Can I ask you to address this maximum minimum argument made by your opposing
The floor, not a ceiling. We agree that the statute sets a ceiling, not a floor, but it is within Verizon's purview and wireless companies' purview to set the limits that are necessary to reach to the next tower or to fix the coverage gap that exists. With our towers operating completely within limits, in fact, well within limits, and if we start changing the limits on individual towers, you know, we keep talking about this one tower, but if you change those RF emission limits on that one tower, you're going to change the range that signal goes. And so you're going to start creating coverage gaps, even though there's sufficient towers in place, those gaps would not exist. So it's, you know, it's not the one tower, it's all of the towers. And again, that it could be set lower might not achieve the purposes of that particular tower in reaching to the next tower.
Thank you.
Thank you, Your Honor.